Welcome to our Spotlight on ESG video series. In this instalment, we'll focus on ESG litigation. My name is Heather Gagen. I'm a partner in our dispute resolution practice, and I'm joined by my partner Stephanie Lee and by our senior associate Charlotte Angwin. We have a history at Travis Smith of advising clients on a range of ESG risk and litigation, working closely with our operational risk team. That's because the regulatory landscape on ESG risk really informs the shape of the type of ESG litigation that we're increasingly seeing. As a practice, we are experienced in handling ESG litigation for our clients, including novel tortious claims such as parent company liability actions and group actions. We also provide preventative counselling to our clients, again working closely with our operational risk teams as they work to understand how the dynamic developments in this area are continuing to present commercial and strategic challenges for their businesses. In this video, we highlight 3 emerging areas of ESG risk and litigation and consider the global and domestic implications of them for corporates and other organisations in their sector. We're going to start first by looking at parent company liability litigation claims, and for that I'll hand over to Steph.
Thanks, Heather. I think it is safe to say that one of the highest profile areas of ESG-related litigation before the English courts in recent years has been parent company liability claims and value chain litigation. So to set the scene, these are negligence-based claims which seek to impose a duty of care and thereby liability on UK domiciled entities in respect of harms alleged to have been caused to the claimants at the hands of third parties. But to be very clear, these aren't attempts to pierce the corporate veil. On the contrary, they seek to impose direct liability on the defendants, and effectively it's tort-based liability of a novel kind. In parent company liability claims, the central allegation tends to be that the UK domiciled parent company, and that is frequently the topco of a multinational group and often a listed topco, that UK domiciled entity is liable for wrongs alleged to have been committed by one of its overseas subsidiaries. And often these claims focus on the degree of control exerted by the parent company over the relevant operations of the overseas subsidiary in connection with the alleged harm. In value chain litigation, the UK entity is said to be liable for harms alleged to have been committed in its global value chain, so effectively by third parties with whom the UK entity, the defendant, may have only the most distant commercial relationship. These claims tend to centre around ESG-related harms, so environmental pollution or contamination, or impacts such as human rights abuses. And they're frequently large-scale claims because, whilst they can be brought by one claimant, they're often brought by groups of claimants and invoke the English court's group action regime. Another thing to note about these claims is that by the very nature of the allegations involved, they tend to impose significant reputational pressure on the defendants, and it isn't uncommon to see that reputational pressure brought to bear in the context of the litigation to good effect. It's important to note that despite the high profile of these types of cases before the English courts in recent years, particularly in the context of the key cases of Vedanta, Okparbi and Moran, the law remains really quite unsettled in this area as to the scope and indeed even the existence of the type of negligence-based liability that's alleged. And that's because the courts have looked at these cases in the context of early skirmishes as to jurisdiction and applications made for strikeout, and they have yet to consider a case at full trial and therefore have yet to deliver a full reasoned judgment in respect of the substantive issues in play. And I think why we haven't seen a case of this nature go all the way as yet may have something to do with the reputational pressures that I mentioned earlier. We often see cases of this sort settle at an early stage because of the reputational pressures that are brought to bear on defendants. So where does that leave us? Well, in short, it means that it is very difficult to assess in the long term what the litigation risk is in respect of claims of this nature. I think one thing I can say, although it's not particularly groundbreaking, is that there will be developments in this area in the coming years, but probably not before a prolonged period of uncertainty as to the nature and extent of the type of liability involved.
Thanks, Steph. The next area of ESG litigation risks that we'll consider are so-called greenwashing claims. And in fact, this is a very wide bucket of potential litigation risk. What it derives from is the fact that corporates are increasingly having to make statements about their ESG credentials in public. Some of that is driven by regulation, such as EU SFDR regulations, or in the UK, the Modern Slavery Act. In addition, there are further proposals for regulatory obligations, such as human rights due diligence regimes, or so-called failure to prevent legislation, including here in the UK. On top of that, there's a host of so-called soft law or voluntary frameworks, such as UN Guiding Principles or OECD guidelines. And all of those taken together have, over recent years, encouraged corporates to increasingly say and make statements about what they are doing, how green they are, how sustainable their products are, what regard they have to human rights in their own businesses and in their supply chains. The risk here from a litigation perspective is that those statements are weaponised in future litigation, i.e. a corporate or an organisation is accused of falling short of what it said it would do in the realm of ESG commitments. This puts businesses in something of a sort of between a rock and a hard place, because on the one hand, they're either having to make disclosures about their ESG credentials, or their commercial partners and their consumers want them to, and they as a business want to say what they're doing. But of course, the future is always uncertain, and that leaves them liable to accusations that they have failed to live up to the standards that they have sought to build or enhance their business with. Globally, we can see different types of greenwashing claims emerging, and a lot depends on the type of securities laws in a particular jurisdiction, the attitude of the courts in a particular jurisdiction, and also increasingly alternative ways in which greenwashing claims could be made. For example, to regulators. So we've seen the SEC in the US set up its own ESG task force, and here in the UK, we have the FCA increasingly interested in complaints made to it about allegations of greenwashing by businesses. There are very, very active NGOs in this area, and activist shareholders are also increasingly a cohort who may become involved in these types of claims. So across the globe, we can see in different jurisdictions, different types of greenwashing claims being made. And the way that those will eventuate, how successful they will be, how claimants will grapple with issues such as proving financial loss and recovering damages for it, all remain to be seen. But as Steph says, the theme here is this is a very dynamic area, and greenwashing claims are no different. Turning to perhaps the most dynamic and headline-grabbing area of all, climate change litigation, I'll hand over to Charlotte.
Thanks, Heather. Climate change litigation is a less developed area as far as the English courts are concerned, but the global litigation landscape is dynamic, and our view is that climate change litigation is going to become increasingly high profile in the English courts over the next few years. Across the world, we're seeing a range of novel cases being brought with the aim of effecting action on climate change. The type of litigation is activist-driven, giving it very unique dynamics. And in particular, the bringing of the action itself can fulfill a key objective of the claimants. This is because the actions typically bring a lot of media attention and focus on the defendant's climate change record. The legal arguments deployed in the claims can be highly novel and are by no means guaranteed in succeeding. However, the agenda of the claimants means that the claimants will not necessarily be dissuaded from bringing the actions. So I'm going to run through a few recent cases which show how different the approaches that tribunals are taking globally on climate change litigation. First of all, in last year's high-profile Miller de Fonseca claim in the Dutch courts. In that claim, the Dutch courts ordered against Shell that Shell needed to use as a guideline for its global corporate policies a reduction of 45% of its carbon emissions relative to 2019 values. Now, that claim is under appeal, but it's really interesting to note that the Dutch judiciary were willing to impose such a carbon emission target against an independent corporate, albeit that corporate was a huge global energy company. So importantly in that claim, the claimants succeeded in convincing the Dutch courts that in relation to an unwritten duty of care in the Dutch legal system, that soft law human rights issue framework should be applied. This is really interesting, in particular because such a framework could also be transferable to the English law framework. However, elsewhere, what we've seen is that claimants have been less successful in trying to bring climate change action through the courts. In a recent claim in Fonterra in the New Zealand Court of Appeal, the claimants, who were a vulnerable Maori community, their claim was rejected in its entirety against 7 greenhouse gas emitters. In that claim, the claimants were unsuccessful in bringing a claim based on a novel duty of care. And also, notably, the court considered that climate change required a sophisticated regulatory response at a national level supported by international coordination. The courts were simply not the right place to be bringing climate change action. The Fonterra claim was also referenced in the recent Sharma claim in the Australian courts. In that claim, a claim brought by a group of children in Australia against the Minister for the Environment of Australia, the claimants were challenging his decision to expand a coal mine. Referencing Fonterra, the Federal Court of Australia found that climate change policy should be left to democratically elected legislature and the executive. In that case, the court also found that although a government might owe a duty of care to its citizens, it was not willing to impose such a duty of care in that instance. Now, as I noted at the beginning, climate change litigation in the English courts is relatively nascent. However, it is worth noting a recent decision in the administrative courts. In that case, the claimants, Friends of the Earth, failed to persuade the court that they should quash a decision made by the government department, the UK Export Finance. That decision was in relation to an investment of 1.5 billion into a liquefied gas development in Mozambique. Now, notably in that case, the 2 presiding judges were unable to agree on a decision, but the claimants have been given the right to appeal, so watch this space. Now, those are only a few examples of climate change litigation and how that litigation is developing globally. How that continues to develop across the world and in the UK remains to be seen. But given the huge amount of global and societal interest in climate change, we expect that this continue to be an increasing trend in years to come.
Thank you so much for joining us for this episode of Spotlight on ESG, which focused on ESG litigation risk. As you can see, ESG litigation is certainly a dynamic and developing area. We can see the courts themselves grappling to adapt existing legal frameworks to deal with novel causes of action that are being alleged. And we can see NGOs, consumers and businesses all grappling with the way and the shape in which this risk might develop and the ramifications for businesses and consumers as it does. There are no quick fixes, there are no easy answers, but this does underline the need for businesses and organisations to really focus on how these trends are developing and what practically they can do to balance the need to run their businesses and seize the opportunities that a commitment to ESG gives them while mitigating potential risks as they appear on the horizon. Thank you so much.